thesis or any people wanting to take the next bar exams. Eventually, we will probably have seats here on the stage. Okay, so you started your review yesterday with a transport strike. You should pray that there be no transport strike on the first Sunday of the bar exams. Baka ano. Anyway, political law has always been the easiest subject in the bar exams. Ito ang pinakamadali sa lahat ng examen. Mas madali pa ito kaysa legal ethics at sa legal forms. Ang problema lang, ang kumukuha ng exam ang nagpapahirap din sa political law dahil sa nervyos at yun. I have heard of a number of bar candidates who could not even write their names on the first Sunday. Parang, you know very well that when you go to your assigned room, you'll be given notebooks. These are your examination booklets. Sewed to the notebook is a small envelope which is supposed to contain your name. So the first thing you do there is to take out that envelope, write your name on it. The card is supposed to be placed back inside the envelope. The envelope is sealed, signed by the watchers. Ganyan. Yung aking isang kaibigan, yung card, maliit lang yun. Kasi yung maliit lang yun. Juan ang kanyang pangalan. Pagsulat niya ng J, mula sa itaas ng card hanggang sa buong notebook sa nerves niya. Kaya after what you have gone through in law school, of course that applies only to some. In the case of others, you did not go through anything at all. So, yun. But I'm saying this because you should not really be under so much stress, under so much pressure. Wala ka nang ginawa kundi magbasa. Pagkising mo, basa ka kagad. Nakakalimutan mo ng kumain, matulog, ganyan. So, lalo na sa last week, yung last week before the exam, wala ka ng tulog noon, puta na kasi ayop, ang dami pang makasabi. Lalo na pag may nakausap kang kaklase, nakukuha ng isa, sabi, ay, sa bagay ako, naka-4 readings na ako. Kaya hindi pa ako nagdadaan. Huwag kang maniwala itong karotado yun. Hindi tama, hindi totoo yun. Naka-4 readings ka, ganun. Ang ibig sabihin na naka-4 pages na siya. Kaya binabasa. Actually, it's like this. Pag medyo relaxed ka lang, hindi ka masyadong under pressure. So, after you write your name and after the watchers have signed that envelope, then they will distribute the examination questions. The questions are placed face down on the armchair. Face down yun. Kasi you wait for the second bell. Pag second bell, saka nabubuksan mo. Of course, the first page contains instructions. And the first page tells you how many pages the questions are. Because baka kulang ang iyong examination questions, titignan nyo rin yun. I-check nyo kung tama ang pages. Dahil baka perfect ka, pero 6 na pages, wala. Diba? When the second bell rings, that's when you're allowed to read the examination questions. And then you read, of course, you read the instructions first. You feel you need instructions, but it's not bad for you to read the instructions first. And then you go to the first question. And normally the first question is not difficult. Except in a number of examinations where what is the writ of amparo, for example. That is the writ of amparo. Marami kaming estudyante na hindi talaga nakakuha ng amparo. And so they went on to the other questions they could answer. After which they went back to amparo and they thought about amparo and they could not. Because that was the first time they heard the writ of amparo. So yun. Yung iba did not want to leave the first page blank, yung wala kang maisagot. Pero yung iba naman, miski gustong sumagot, wala namang masabi. So yun. Of course, there were some very enterprising candidates who wrote, Amparo is the name of the wife of the bank examiner. At least meron siyang sinula. Pero as you go along, makikita nyo na basta hindi ka lang masyadong nervyos, ano yun eh, you recall the things that you learned. You recall the things. In my case, I could even recall the class recitation. In almost all of the subjects in the bar exams, there were instances when after reading the question, I would recall the class recitation. Si ganito, nagre-recite nito, pinapawisan na nakatayo, pero yan, sinasabi ng professor, ganyan. It comes back. And as long as you do not yourself prevent it coming back by your tension, the pressure, the nervyos, the whatever, darating yun. Ang komparasyon ko nun parang gripo. Binuksan mo gripo, tuloy-tuloy na yan. Pag naumpisahan mo na, masagot. Parang gripo binuksan na, tuloy-tuloy na tulong ng tubig. Eh, dapat lang may tubig sa pinanggagalingan. Wala. Makahangin lang. Mahangin lang lalabas ng gripo na yun. So yun. And so, especially on the first Sunday, you should not allow your own nervousness to take the better of you. Relax ka lang. Ano naman itong bar exams na ito, wala naman sinabi yan kung tutusin mo. Saka taon-taon naman meron eh. Ganun lang yun. And in the last year's bar examinations, for example, the easiest subject was really political law. Even in the results, I understand that 39% passed political law and only 16% passed legal ethics. Only 15% passed remedial law. Of course, talo yung political law ng labor because there were 55% passed labor in last year's bar examinations. Pero on the whole, hindi bumababa ng 25% political law passing. Why? Because the bar examiners, the chairman, naturally asks the bar examiner in political law not to make the questions very difficult. Dahil isipin nyo ang laking iskandalo sa Lasal. Kung pagkatapos ng morning exam, wala nang bumalik doon or today. Dahil lahat ang iniisip is qualified in political law. It's like that. It's not going to be ano. Kaya ako, I have been doing this lecture on a circuit kung saan ako nakarating lecture sa political law. Hindi talaga ako kinakabahan dito. Kaya hindi naman ako kukuha ng exam. Pero hindi, wala ako. I am certain that in political law, kayang-kaya. First, the subject itself, even if there are so many subject areas, has only very, very few principles. Hindi masyadong maraming principles. Kukunti lang. Ang enumeration hindi gaano marami. Requisites ng principles, limitations ng principles, ganyan. Yun lang naman ang kailangan talaga makabisa. And then, as long as you can remember the principle, the requisites, the limitations, confronted with a problem, all you have to do is apply. Right? Apply the principle and look at the facts, see if the requisites or the elements are there, and then, if not, then say so. So, kayang-kaya talaga. Hindi ka mukha ng sigilo na sa lawak, sa dami. Mahirap na siya din. Eh, di ba, in fact, civil law is still a better, an easier subject as far as I'm concerned. Dahil ang civil law substantive, and laging mayroong philosophy, may reason behind law. Ang pinakamahirap ang remedial law dahil walang reason yun eh. Walang philosophy behind it eh. Rules, ito, procedural rules. You don't even get to know why this is the procedure follow. Bakit ganito ang ginagamit? Ba't hindi ganito? Ba't hindi ganyan? Hindi eh. Kasi procedure eh. Iyan at yan lang ang dapat mong gawin. Hindi ka mukha ng substantive law na meron. You can always fall back on reason, on logic. Ganyan lagi yan. So, okay. We move on. Theoretically, about 10 years ago, this was announced every time there is a meeting between the law deans and the chairman of the Bar Examinations Committee. Ito ang coverage ng political law and public international law. Ina-announce yun doon. Constitutional Law 1, which covers the structure of government, 30%. Constitutional Law 2, which covers basically the Bill of Rights, the fundamental powers of the state, citizenship, the national economy, 30%. Administrative law, 5%. Public officers, 5%. Election laws, 5%. Local governments, 5%. And public international law, 20%. Yan. Normally na yan. But then, the chairman found out later that a number of their chosen examiners could not strictly follow this. So, hindi na ina-announce na, hindi na basta. Ito na lang ang buong coverage, bahala ng examiner kung anong distribution. Plus, in last year's bar exam, I attended the breakfast meeting with the Chief Justice and Justice Kisumbing. Justice Callejo was also there. The breakfast meeting held on the first Sunday of the bar examinations. After the second bell rang, first Sunday, we were allowed to enter La Salle. There was a room reserved for this meeting. They had breakfast ready for us. And even as we were already gathered there, with low deans mainly. I was there because I represented a low dean who could not make it. After about another 15-20 minutes, then the Chief Justice, Justice Kisumbing and Justice Callejo entered and then welcomed the people there and then said that breakfast was served. But before that, he asked that copies of the examination questions be distributed. Kulang ang distributed na examination questions. We waited for more copies, even as we ate breakfast. After that, the president of the Philippine Association of Law Schools said, maybe we can ask for comments. Maybe we can ask Professor Nachura to give us a comment, to comment on the questions. But after I had read the questions, kontento ako dun sa examination questions. Kaya sinabi ko dun sa, nakikinig naman sila Chief Justice dun. Sabi ko, on the whole, the examination is reasonable. Insofar as distribution of the questions among the subject areas is concerned, reasonable. On the length of the examination, reasonable. However, there are some questions that are not very reasonable, sabi ko. Hindi na katungkin. Mukhang sumamaan. Mukha niya naman, Justice Kisumbing. Sabi ko, the questions that are not reasonable are the questions that I did not cover in my lecture last night when I gave last minute tips to the mga night. It broke the ice and ayos naman, wala naman. So that's it. Wala naman. Ngayon, hindi na rin nangyari sa amin noon. In our year, while we were supposed to have 80% political law and 20% public international law, nabaliktad. 60% international law ang tanong sa amin and only 40% political law. But I don't think that will happen again. Okay, so we go to the subject matter. Political law, my assignment is, of course, to cover Constitutional Law 1, Constitutional Law 2, administrative law, public officers, election laws, and local government. So, yan. Over the next 3 weeks, we will be covering the whole thing. We will try to go as deep as we can and look at the variations, the nuances, etc., the principles involved. And then during the pre-week, I will give you the answers already. Not the questions, the answers. Kayo na ang bahala kung saan ang answers, ang question nyo ilalagay. I will give you the answers to the questions. So yun. All of these subject areas basically involve the study of the Philippine Constitution. And so the Philippine Constitution we refer to is the 1987 Philippine Constitution. There are possibilities, class, that next year we may have constitutional change. So please pass the bar exams now, because next year you might have a new constitution to study. Iba na naman ito. So yan. Those of you who are only starting to read very, very seriously and when you read, kasama ng pag-memorya, ito pala isa, of course, when you review at pagbasa mo, kasama na ang pag-memorya, kasi chances are you may not have time to go back to the same thing again. Even if you do not go very fast, isama nyo na yun. Kasi baka mamaya hindi mo na mabalikan. Pag nag-memorya ka naman, I am sure na babalik yun at babalik. Pag nakita mo ng question. Ganon lang. Ganon sana. And so, don't try to make 4 readings or whatever. Hindi mangyayari yun. It will not happen. You force yourself to do 4 readings. That means, baka pagdating ng September, payat ka na, hindi ka na makakarating yun sa dasal. Wala ka na. Kasi wala ka ng tulog nun. Okay. Second, please do not force yourselves to read and read pag nalaman nyo na medyo mahina na ang inyong absorption, mahina na concentration. It is doubly self-defeating. Why? When you force yourself to read, even if the physical faculties you have no longer respond very well, you use more effort. That means you tire yourself more. Second, it will give you a sense of false confidence. When you read and your absorption capacity is, say, 75-80% or higher, and you are physically fatigued, baka mamaya ang binabasa mo 30% na lang, 30%, 25% na lang ang pumapasok at nare-retain mo. Pipilitin mo pa rin sarili mo, pipilitin mo pa rin. Dahil nakarinig ka rin sa bilang, tapos na ng subject ito, tapos na ng ganyan. Okay. Later, sasabihin mo, hindi, nabasa ko na yan. Nabasa mo nga, pero 25% lang ang pumasok sa utak mo eh. Kung doon ka tanuin sa 75% na hindi pumasok, paano ka? Tapos ka. So, the idea is, give yourself a chance to rest, to relax. The worst thing that can happen is for you to get sick during the bar exams in September. You get sick before that, masama pa rin yun dahil that means you cannot really read. So, ganun lang. Pag mararamdaman mo pagod na pagod ka na, huwag mong pilitin. Stop, relax, maybe exercise, maybe go out to a movie, go out drinking, whatever. So that you forget the bar exam. That is the idea. Because after that, when you go back to reading, maganda naman, mararamdaman mo, ayos na naman. This goes on for several days. And then, nararamdaman mo, masama na naman. Inom na naman. Ay, yung mga babae, hindi naman pwedeng inom na inom. You go out, see a movie, go on a date with your boyfriend, whatever. Basta makalimutan mo muna ang bar exam for a given time na makapag-rest naman ang utak mo, makapag-relax din ang iyong body, ganyan. That's okay. Okay. In the course of the lectures, we will have tips like this, in addition, of course, to the principles in political law that we will talk about. And so, to go back, the study of political law is basically a study of the 1987 Constitution. Of course, you have some special laws that will have to be taken up and mastered, as it were, because they invariably are sources also of bar examination questions. I am sure those of you who have started reading already have read the Philippine Constitution. Now, as you read the Philippine Constitution and as you start memorizing principles, if you want to memorize certain articles in the Constitution, if you can memorize only one article, it should not be Article 1 because that's a short text. If you can memorize one article, I suggest you memorize Article 3. There will be questions which will call for answers that are taken from the provisions themselves. You don't even have to look for jurisprudence. By recalling the provisions. No, one of the questions given to us in our bar examinations was, what are the requisites of a valid warrant of arrest or valid search warrant? Under the present Constitution, you find that in Section 2 of Article 3 of the Constitution. Yun lang. If you have memorized that, walang problem if such a question were asked. Now, if you can memorize 2 articles, I suggest, in addition to Article 3, memorize Article 2. Article 2 may not be the source of a bar examination question per se, but the principles in Article 2 can help you not only in political law but also in other subjects. Of course, there are some who have already memorized the Constitution. If you have memorized the Constitution already, do not unmemorize the other articles anymore. So, yun. Alright. Yung pag-umpisa natin, talaga yun. Paano lang yun. Pamparelax. Alright. First, we talk about general principles governing the 1987 Philippine Constitution. The 1987 Philippine Constitution took effect February 2, 1987, the date of the plebiscite at which the draft Constitution was approved by a majority of the votes cast in that plebiscite. So, that is supposed to be the effective date of the 1987 Constitution. We will not discuss the contents, the form, etc. We go immediately to the matter of interpretation of the Constitution. In the case of Francisco versus House of Representatives, even as Francisco cited liberally Civil Liberties Union versus Executive Secretary, the Supreme Court enumerated a number of rules used in interpreting or construing provisions of the Constitution. The first rule that should be applied whenever there is need to understand a certain provision of the Constitution is verba leges, the word of the law itself. Under this principle, words used in the Constitution are supposed to be given their common meaning, their generally used meaning. And so, unless the word is a highly technical word, which has a highly technical meaning, you are supposed to give the words found in the Constitution only their ordinary common meaning as they are used in outside, as they are used by people not necessarily lawyers or constitutionalists or commissioners of the Constitutional Commission. Okay. Where there is some difficulty to arrive at the common usage or the common meaning of the word, then the Supreme Court suggests that you use ratio legis et anima. So the first is verba legis. The second is ratio legis et anima. You determine from the words, since the words are perhaps not understandable, or that the use in which they find themselves is ambiguous, then you look for the intention of the framers of the Constitution. In the case of Civil Liberties Union versus Executive Secretary, which was referred to in Francisco versus House of Representatives, the Supreme Court said that provisions of the Constitution are to be understood in the light of the circumstances prevailing when the provisions were adopted. And they are to be understood in relation to the problems that they are supposed to remedy. They are supposed to be understood in the light of concurrent circumstances. When even this proves, of course, the intent, when the intent of the framers shall have been ferreted out, then that is how the provision is understood. Now, if there are two or more provisions on the same subject, and there may appear to be some contradiction, the Supreme Court said the rule that is to be applied is medyo mahirap itong mga lapin na ito. Ewan ko kung paano pagbasa niyan. For all these high-sounding Latin terms, it simply means that the constitutional provision, the Constitution has to be interpreted as a whole. Specific provisions on a similar subject must be reconciled, read together and reconciled in interpreting the Constitution. Now, class, let me just give you one example, the case of Tañada versus Angara. In Tañada versus Angara, Wigberto Tañada went to court to challenge the constitutionality of the Senate approval of the Philippines' participation or membership in the World Trade Organization and its being signatory to the General Agreement on Tariff and Trade. Then Congressman na lang si Tanyada nun. Then Congressman Tanyada said that when the Philippine Senate approved the membership of the Philippines in WTO and its being a signatory to the GATT, it in effect violated Section 19 of Article 2 of the Philippine Constitution, which speaks of an independent and self-reliant economy effectively controlled by Filipinos. The Supreme Court rejected the Tanyada contention and said Section 19 should be read along with Section 1 and Section 12 of Article 12. It should also be read together with provisions of Article 13. And so, that is how your Constitution is to be interpreted, not specific provisions taken out of the context of the whole, but provisions on the same subject matter interpreted in harmony with one another in order to give effect not only to specific provisions but to the entire Constitution. Of course, the Supreme Court then said, if it is really difficult to arrive at this, particularly the intent, then you may use extrinsic aids in construction, which will include even having to go into the debates in the Constitutional Convention and so on. Although there is something there that the Supreme Court said, where the word is clear, you do not need to go to extrinsic aids. Because the debates, the Supreme Court said, the debates in the Constitutional Commission will not prevail over what the word used is understood in its common usage, as understood by the people who have adopted the Constitution, who have approved the Constitution. Yeah, all right. Then class is still on interpretation. Generally, provisions of the Constitution are self-executing, except it seems many of the state policies found in Article 2, where the Supreme Court has time and again said that these are not judicially enforceable rights. A self-executing provision, of course, is a provision of the Constitution that can be implemented directly, independently of the need for legislative action. There are many provisions in the Constitution that require prior legislative action. In those cases, your provisions are therefore not self-executing. As a rule, the provisions of the Constitution are mandatory instead of directory. And of course, as a rule, the provisions of the Constitution are prospective and not retroactive. Alright. That should take care of interpretation of the Constitution. We move on to changing the Constitution. The generic term used to denote any change in the Constitution is amendment. In a specific sense, however, amendment is understood to refer to piecemeal or changes in the Constitution, while revision refers to the overhaul of the entire Charter. Whether it be amendment or revision, the provisions in the Constitution that govern are the provisions of Article 17. And so we jump immediately to Article 17. Although the Constitution itself does not say so in so many words anyway, the provisions of Article 17 tell us that the amendatory process, the process of changing the Constitution, consists of two steps. First step is proposal, and the second step is ratification. No change in the Constitution shall take place unless the two steps are complied with. What is proposal, the first step in the amendatory process? Proposal as the first step in the amendatory process refers to the adoption of the suggested change in the Constitution. And the Constitution itself, Article 17, enumerates who may validly propose amendments to the Constitution. This enumeration is exclusive. Only those mentioned in the Constitution may validly propose amendments to the Constitution. No other agency, officer, or instrumentality may validly propose an amendment to the Constitution. Who then may propose an amendment to the Constitution? First, Congress. Congress may directly propose an amendment to the Constitution by a vote of 3/4 of all of its members. Thus, while many constitutionalists feel that the 3/4 vote refers to 3/4 of all the members of the Senate and 3/4 of all the members of the House of Representatives, there are dissenting views. And since we don't have any jurisprudence on this, we accept the fact that there are two views on the matter. The majority view, it seems, is that the 3/4 vote refers to 3/4 of the Senate and 3/4 of the House of Representatives. If Congress does not want to propose direct amendments to the Constitution, but recognizes the need for a revision or an overhaul of the Charter, then Congress may ask or call a constitutional convention into existence. So, the other source of a proposal to amend the Constitution would be a constitutional convention. However, if you read the Constitution, a constitutional convention does not exist at all. It has to be called into existence, and only Congress can call it into existence, or at least initiate the calling of a constitutional convention. So, how is a constitutional convention called into existence? It is called by Congress by a vote of 2/3 of all of its members. Or, if the 2/3 vote is not obtained, by a majority vote, provided that the question of whether or not a constitutional convention may be called into existence shall be submitted to the people in a plebiscite. If the majority votes cast in the plebiscite favor the calling of a convention, then a constitutional convention may be called into existence. But notice that it is Congress that must act first. Without any initiative on the part of Congress, a constitutional convention cannot exist. In the case of Oxenia versus Commission on Elections, the Supreme Court said, Congress is vested with discretionary power, discretionary authority, whether or not to propose direct amendments by a vote of 3/4, or whether or not to call a constitutional convention into existence. It is Congress that has full discretion in that matter. If Congress does not want to propose an amendment or does not want to call a constitutional convention into existence, there would have been a third source of a proposal. And that is the people themselves. Through the exercise by the people of the power known as initiative. Under the Constitution, the people may exercise the power of initiative by filing a petition suggesting the change, suggesting the proposed change, provided that the petition is signed by at least 12% of all the registered voters in the country, provided that each congressional district is represented in the petition by the signature of at least 3% of the registered voters in each congressional district. This petition is supposed to be filed with the Commission on Elections, and it is the duty of the Commission on Elections to determine whether or not the constitutional requirements, particularly the requirement of 12% and 3%, have been complied with. After which, once the COMELEC is satisfied, then the COMELEC is supposed to issue a certification to the effect that there has been compliance with constitutional and statutory requirements. Thereupon, the COMELEC will schedule a plebiscite. The Constitution imposes two limitations on the people's power of initiative. First, that the people may not propose amendments to the Constitution through an initiative due within 5 years from the time of the adoption of the 1987 Constitution. 1987 pa yun, more than 5 years have already elapsed, so that limitation no longer applies. The second limitation is that no proposed amendment through an initiative may be made more often than once every 5 years. The Constitution provides that Congress should, as soon as possible, pass a law on the system of initiative and referendum. That is what is unfortunate, class. It is unfortunate that this provision in Article 17 is not self-executive. By express provision of the Constitution, the people cannot exercise the power of initiative without an enabling law. And Congress is, under the Constitution, called upon to pass an enabling law. In response to this mandate in the Constitution, Congress passed Republic Act 6735, otherwise known as an act providing for a system of initiative and referendum. Under the law, an initiative is defined as the power of the people to propose amendments to the Constitution or to propose and enact national or local legislation through an election called for the purpose. Again, an initiative is the power of the people to propose amendments to the Constitution or to propose and enact national or local legislation through an election called for the purpose. From this definition, we are immediately told that there are three forms of initiative: an initiative on the Constitution, an initiative on national legislation, and an initiative on local legislation. Of course, this also provides for referendum. We will take that up when we go to Article 6. In the meantime, let us look at the initiative that the people may exercise in order to propose amendments to the Constitution. In the case of Miriam Defensor Santiago versus Commission on Elections, the Supreme Court said, however, that the enabling law is not adequate. It did not say that the law is unconstitutional. The Supreme Court said this is inadequate for the purpose of an initiative on the Constitution. Because, sabi ng Supreme Court, while the law provides a certain chapter in the law on initiative on national legislation and initiative on local legislation, it does not contain a chapter or initiative on the Constitution. It does not even contain a provision that spells out what a petition should contain. Accordingly, sabi ng Supreme Court, the provisions of the enabling law are inadequate, insufficient for an initiative on the Constitution. Okay, let us go back a little bit and look at Miriam Defensor Santiago versus Commission on Elections. In 1997, a group of people wanted to amend certain provisions of the Constitution. The main target was the provision in Article 7 that prohibited re-election for an elected president. Several people filed a petition with the Commission on Elections. The petition sought permission from the Commission on Elections in order to gather signatures. Permission lang, asking COMELEC to allow this group to gather the necessary signatures so that they could get 12% and 3% for purposes of amending particularly Article 7 of the Constitution. The first name among the petitioners was a fellow named Delphine, surnamed Delphine. And so this was referred to as the Delphine petition. Senator Raul Rocco, who was the principal author of Republic Act 6735 in the House of Representatives, and he was still a member of the House, filed an opposition. He opposed the Delphine petition. In his opposition, he made allegations that were, of course, in the nature of allegations supportive of a motion to dismiss. From your mastery of remedial law, you know what the grounds for a motion to dismiss are. And when they are raised, even in an answer as affirmative defenses, they are to be treated as if a motion to dismiss had been filed. Okay. And so, the Commission on Elections treated the ROCO petition, the ROCO opposition, and denied, went on to consider the Delphine petition. Raul ROCO did not go to the Supreme Court on certiorari from the denial by the COMELEC of his opposition. It was Miriam Defensor Santiago who filed an original action with the Supreme Court, asking the Supreme Court to order the COMELEC to dismiss the Delphine petition. I have to go through this because I wanted you also to look at the remedial law issue involved. The remedial law issue involved. Considering that you have mastered remedial law. Anyway, you dream of mastering remedial law anyway. Yun. Tingnan nyo. The Supreme Court entertained the Miriam petition for certiorari. It was a petition for prohibition. In fact, sabi ng Supreme Court, the Miriam petition shall be treated as a petition for certiorari, raising in issue the denial by the COMELEC of the ROCO opposition, even if it was not ROCO who went up to the Supreme Court, but Miriam. There may be a little procedural infirmity here, but it is the Supreme Court that makes the rules anyway, so wala rin tayong magagawa. No? Siguro ang sabi ng Supreme Court, kung hindi natin ito, ibabalik natin, halimbawa, aakyat din naman sa atin ulit ito, so we may as well decide this now. And so, on the basis of this, the Supreme Court said, grant the Miriam petition. Order the COMELEC to dismiss the Delphine petition. Why? On two grounds. First, the Supreme Court said, the provisions on initiative in the enabling law are inadequate, insufficient. They do not provide for the manner of how the people can exercise the power of initiative. Yon. And second, the Supreme Court said, the Delphine petition should be dismissed also because it does not propose an amendment. It is not supported by the signature of 12% and 3%. Kaya hindi dapat pagkaksayan ng panahon ng COMELEC. I-dismiss na yan. And so the Supreme Court ordered the COMELEC to dismiss the Delphine petition. And the COMELEC dismissed the Delphine petition. Okay. A few months after that, the same group of Delphine, this time they were a bigger group. After the denial of the Delphine petition in the Miriam Defensor Santiago ruling, these people went around the country and solicited signatures, and they were able to get more than 12% of all the voters in the country, complying with the 3% in each of the congressional districts. And now, this group went back to the COMELEC, filed their petition with the proposed amendment already, asking the COMELEC now to look into whether or not the petition complies with constitutional requirements. Takot ang COMELEC, sabi ng COMELEC, kasasabi lang ng Supreme Court na inadequate ang enabling law. COMELEC dismissed the petition filed. This was a petition filed by a group who called themselves Firma. Okay. Akyat ang firma sa Supreme Court. The Supreme Court reiterated the Miriam Defensor Santiago ruling and said, the enabling law is inadequate. We cannot hold any initiative for the people because the law itself is insufficient to allow an initiative on the Constitution. So that's it. Yan. Tapos, up to now, unfortunately, this happened in 1997. 8 years have already passed. Congress has not been able to provide the needed provisions of the law that would then allow the people to exercise this power granted to them under the Constitution, known as the power of initiative on the Constitution. In last year's bar examination, there was a question precisely on initiative, but it was a question directed mainly at the constitutional provision. When may the people directly propose amendments to the Constitution? At least, ang preface yata noon was under the Constitution. Under the Constitution, are the people, may the people directly propose amendments to the Constitution. Parang ganyan. So, basically, constitutional provision lang. Alright. So, today, if we are to be realistic about it, there are only two possible sources of a proposed amendment to the Constitution: Congress and a Constitutional Convention. Now, you have to recall what the Supreme Court spoke of when it was asked to rule on the question, what is the status of a constitutional convention vis-a-vis the three other branches of government? When a constitutional convention shall have been validly called into existence, how does it stand in relation to the legislative, the executive, the judicial branches of government? The Supreme Court said there are three schools of thought on the matter. First, the doctrine of constitutional sovereignty, which says that a constitutional convention, because it exercises powers that directly attributable to the people, is superior even to the legislative, the executive, and the judicial branches of government. The second school of thought says that because a CONCON is merely a creation of Congress, it is inferior or subordinate to the three branches of government. The Supreme Court said, however, that in our jurisdiction, whenever a constitutional convention shall have been validly called into existence, and when it exercises powers within the scope of its authority, then a CONCON is co-equal to and independent of the three branches of government. All right. If a valid proposal shall have been adopted by Congress, or where a CONCON has been validly called into existence and a constitutional convention proposes an amendment to the Constitution, or assuming that Republic Act 735 shall have been amended and the insufficiency shall have been cured, if the people themselves, through initiative, validly propose an amendment to the Constitution, that proposed amendment shall become part of the Philippine Constitution if approved by a majority of the votes cast in a plebiscite that is to be held not earlier than 60 nor later than 90 days from the approval by Congress of the proposal if it comes from Congress, or from the approval by the CONCON if it comes from the CONCON. If the people, assuming that they can already exercise initiative, propose amendments, then the 60 to 90 day period shall be counted from the date the Commission on Elections issues a certification that the petition complies with both constitutional and statutory requirements. With the Constitution itself prescribing the period within which the plebiscite is to be held, we are saved having to discuss so many decisions of the Supreme Court. This used to be called the doctrine of proper submission. Be that as it may, there are two things that I would like you to remember in connection with the ratification process and the doctrine of proper submission. First, Commission. Ramon Gonzalez versus Commission on Elections, which was reiterated in Oxenia versus Commission on Elections. What does Gonzalez versus Comelec say? It says that the plebiscite for the ratification of a proposed constitutional amendment may be held simultaneously with national or local elections. That is still valid case law today. The second thing I want you to remember is that principle laid down by the Supreme Court in the case of Tolentino versus Commission on Elections. In Tolentino versus Commission on Elections, the Supreme Court said, if it is a constitutional convention that proposes the amendment, but the CONCON was precisely called into existence to revise the Constitution, then a constitutional convention cannot submit for ratification piecemeal amendments. No piecemeal amendments shall be submitted for ratification by the CONCON, where the CONCON has been called into existence precisely to revise the Constitution. The Supreme Court spoke of the 1935 constitutional provision which spoke of election. Isa lang daw, hindi maraming elections. Isa lang, singular. But more importantly, the Supreme Court said, if a CONCON is tasked to revise the entire Constitution, it should not be allowed to submit for ratification individual provisions because the people would be deprived of a proper frame of reference. Hindi alam ng tao kung ano pa ang ibang magiging provisions. So they cannot intelligently vote on one particular provision when they do not know what the other provisions of the Constitution will be. And so the Supreme Court rejected the proposed plebiscite upon petition of then Senator Tolentino. Actually, class, the 1971 Constitutional Convention was inaugurated on June 1st, 1971. The convention worked from June, July, August, September. After 4 months of working, the convention could show that it had approved only one resolution. The resolution reducing the voting age from 21 to 18. Afraid, the leadership of the convention, afraid that the people might be disenchanted with their very unsatisfactory record of achievement, as it were, decided to submit that one resolution to a plebiscite simultaneously with the November 1971 elections. Senator Tolentino went to court to stop the holding of the plebiscite, and the Supreme Court agreed with Tolentino. If the CONCON cannot submit piecemeal amendments to the Constitution. All right. Just two more things, class, on amendment. One, the issue of amendment. Is it a political or a justiciable question? Starting with Haveliana, the Executive Secretary, and consistently up to now, the Supreme Court has said that this is a justiciable question. Justiciable question because invariably the question will boil down to whether or not the provisions of Article 17 have been complied with. And when the issue is compliance with constitutional guidelines, principles, and requirements, then the issue is justiciable and not political. The other thing I want you to remember is that through the entire process, when Congress proposes an amendment directly, when Congress calls a constitutional convention into existence or at least initiates the calling of a convention, when a convention has been called into existence already and it now proposes amendments to the Constitution, or when the people, assuming that the inadequacy of the law shall have been cured, or when the people directly propose an amendment through an initiative, or when the people vote in the plebiscite to be held within 60 days, not earlier than 60, not earlier than 16 or later than 90 days from the approval of the proposal or from the issuance of the certification by the committee. What power do all of them exercise? They exercise the constituent power. That is why ang sinasabi dito, when Congress directly proposes an amendment to the Constitution, Congress then must sit as a constituent assembly and not as a legislative body, because the constituent power is different from the legislative power. The legislative power is defined as the power to propose, enact, amend, and repeal laws, while the constituent power has always been understood to refer to the power of the people to propose amendments to the Constitution or to effect permanent changes in the political structure of government. Imbong versus Commission on Elections. Briefly, although I don't know if we can be brief about Imbong. In 1967, Congress, acting as a constituent assembly, adopted and approved by a vote of 3/4 of all of the members of Congress, three resolutions of both houses. The first resolution approved was to amend the provisions of the legislative department in the 1935 Constitution by increasing the number of members of the House of Representatives from 120 to 180 members. The second resolution called for a constitutional convention to revise the 1935 Constitution. And resolution number 3 was an amendment again of a provision in the legislative department in the 1935 Constitution to allow members of Congress to run and be elected as delegates to the Constitutional Convention without forfeiting their seat in Congress. Yan ang tatlo. That same year, in November of that year, 1967, Congress submitted to a plebiscite Resolution number 1 and Resolution number 3, increasing the number of representatives in the House to 180 and allowing members of the House to serve as CONCON delegates without forfeiting their seats in Congress. The people rejected the two proposed amendments. Pasensya na kayo dahil ako tinitingnan ko muna kung meron ditong bumoto na noong 1967. Okay. So, nawalan ng gana ang Congress. Tangina pala, hindi pala tayo pwede roon. Nayayang ng tao eh. Relax na muna tayo. In the meantime, the seeds of activism had started to germinate. People like Ruben Torres and Cadre in the University of the Philippines and several other student activists led these almost daily rallies at Plaza Miranda. Mga estudyante muna. And then sinakyan na rin ng mga kaliwa, sinakyan na ng mga kanan, at sinakyan ng mga nasa gitna. So, in 1969, Congress saw that this activism could not be contained. And so to divert the people's attention, Congress passed 69 later. Resolution about Houses number 4, reiterating the call for a constitutional convention and stating therein that Congress should now decide how to allocate the number of delegates to the convention, the manner of electing delegates, etc., etc. In 1970, Congress passed Republic Act 6132, otherwise known as the Constitutional Convention Act of 1970. 6132 now provided for the number of delegates in the specific congressional districts. It provided for rules on the election of delegates, etc., etc. Okay. Now, on the basis of Republic Act 6132, election of delegates to the Constitutional Convention was then scheduled for November of 1970. Imbong and two other petitioners went to the Supreme Court, asking the Supreme Court to stop the holding of election of delegates to the convention. Because according to him, Republic Act 6132 was unconstitutional. The argument of Imbong was, under the 35 constitutions, Congress could propose direct amendment by vote of 3/4, and Congress can call a convention only by vote of 3/4. 3/4 still. The resolutions, yung RBH, resolution of both houses, numbers 1, 2, 3, and 4, had all been approved by 3/4 vote. But Republic Act 6132 was not, because it was an ordinary law. It was approved by a majority of those present constituting a quorum. And so, sabi ni Imbong, then this is an unconstitutional law. Because this has to do with the calling of a convention, and under the Constitution, Congress can call a convention only by a vote of 3/4 of all of the members. Under the 35 Constitution kasi ganun. Okay. The Supreme Court said, no, Republic Act 6132 is valid. It is constitutional. Why? Sabi ng Supreme Court, distinguish between constituent and legislative powers. When Congress passed resolutions of both houses 1, 2, 3, and 4, it exercised the constituent power. Accordingly, what was required was a 3/4 vote. But after it had exercised this power, it may now, by simply exercising the legislative power, prescribe the details for the implementation of these resolutions that have been passed in the exercise of constituent power. It is in that sense then that the Supreme Court distinguished between the two, alluding to the legislative power as some kind of a lesser power, which is the power to propose, enact, amend, and repeal laws. And the greater power is the constituent power because that flows directly from the people. It is supposed to be the power directly exercised by the people in the matter of amending the Constitution or in effecting permanent changes in the political structure of government. So yun. Again, kaya ko lang tinake up ito dahil the Article 17 entails the exercise of constituent powers. Article 6, the exercise of legislative powers. Even as you're talking of the same Congress of the Philippines. Okay. That should take care of Article 17. We have only 17 more articles to go. Ready na? All right. We move on to still one other general principle on constitutional law, and that is the power of judicial review. The power of judicial review is defined as the power of the courts to determine the validity of executive or legislative acts in light of their conformity with the Constitution. What are we looking at here, Pa? We are looking at the power of the courts to test the validity of legislative and executive actions and see if they are consistent with the Constitution. Because if they are not, then it becomes the duty of the court to strike down the legislative or executive act because of its violation of the Constitution. This is not supposed to be an assertion of supremacy by the courts or superiority over the other departments. The act of the court in declaring a legislative or executive act unconstitutional and therefore invalid merely reinforces the supremacy of the Constitution itself. And so at this stage, perhaps, we can look already into how this is exercised. Within the context of the doctrine of separation of powers, there are three major branches of government exercising the powers of government. Each of these branches of government is vested with authority to check possible abuses and possible excesses committed by the other departments. The power of judicial review is the power inherently granted to the courts in order that the courts may be able to to check possible excesses, abuses, or encroachments made by the legislative department or the executive department into the prerogatives of another department. We will take up the political question doctrine perhaps later when we discuss separation of powers. For now, let us look at certain features of the power of judicial review. First, who in the judicial department exercises the power of judicial review? Definitely, the Supreme Court can exercise this. Even as we say that the power is inherent, we see in Article 8, Section 4, Paragraph 2, a recognition by the Constitution of the power. This provision says that the Supreme Court and bank shall decide cases involving constitutionality of laws, treaties, presidential decrees, orders, instructions, proclamations, rules, regulations, ordinances, etc. So, kitang-kita dyan. Perhaps the better question is, can an RTC exercise the power of judicial review? In the recent case decided by the Supreme Court, the case of Mirasol versus Court of Appeals, the Supreme Court dispelled any and all doubts about it. The Supreme Court said the RTC can exercise the power of judicial review. However, where there is a case pending with the RTC in which a question of constitutional dimension is raised, the Supreme Court requires that the office of the Solicitor General be notified of the tendency of the action and of the issue of constitutional dimension. The Supreme Court said this notice is needed so that the Solicitor General can decide whether or not he has to intervene in the pending action. Otherwise, if no such notice is given, it is as if the Solicitor General were denied his day in court. The Solicitor General, incidentally, if you still do not know it, is supposed to be the lawyer of government. And so, there has to be notice if due process is to be complied with. Notice and an opportunity to be heard. So, yun. Okay. What are the functions of judicial review? Justice Vicente Mendoza, who will not be your examiner anyway. Marami tayong pag-uusapan na kay Justice Mendoza Pero hindi naman palagay ko siya magiging examiner. Ang problema lang natin kung ang examiner niyo believe kay Justice Mendoza. Kaya Justice Mendoza says there are three functions of judicial review. Namely, checking function, the legitimating function, and the symbolic function. The checking function takes place when the courts declare an act of Congress or an act of the executive department unconstitutional. This is an application of the principle of checks and balances because the act either is abuse of authority or ultra vires, or because the act in effect encroaches upon the prerogative of another department, then the courts come in and check the excess, the abuse, or the encroachment by declaring the act unconstitutional. What is the legitimating function? The legitimating function takes place when the courts do not declare a law or an executive act unconstitutional. Because where the courts fail to find any infirmity, constitutional infirmity in the legislative act or in the executive act, then the court says it is not unconstitutional. When the court says it is not unconstitutional, it is as if the court blesses the act, gives it the kind of benediction that will make it a legitimate legal act. The symbolic function is best illustrated, of course, in Salonga versus Panyo, which we will take up in a little while. Now, as far as judicial review is concerned, you have to memorize the requisites of judicial review and perhaps be able to explain each, even very briefly. Okay, so what are the requisites of judicial review? First, there must be an actual case or controversy. Second, the constitutional question or the issue, the question of constitutionality must be raised by the proper party. Third, the question of constitutionality must be raised at the earliest possible opportunity. And fourth, the resolution of the constitutional question must be determinative of the case itself. Okay. Let us go through them very briefly, and we are going to take up a number of things. What is an actual case or controversy? It is a conflict of legal rights, an assertion of opposing legal claims susceptible to judicial determination. So, the Supreme Court said, a request for an opinion will not give rise to an actual case or controversy, and therefore, a request for an opinion will not be ripe for judicial review. The issues must be active, as it were. The issues must be active. They should not be moot and academic. Or, because of certain developments, the issues have not become moot and academic. Plus, we have a number of relatively recent decisions on the matter, on moot and academic. For instance, in the case of Ramon Gonzalez again versus Narvasa, when Ramon Gonzalez went to court to challenge the constitutionality of the executive order issued by President Estrada creating the Preparatory Commission on Constitutional Reform and appointing former Chief Justice Narvasa and a number of other people as members of the Preparatory Commission for Constitutional Reform. Ramon Gonzalez went to the Supreme Court asking the Supreme Court to declare this act unconstitutional because, as we have seen under the 1935 Constitution, the President has no participation at all in the amendatory process. The President cannot propose amendments to the Constitution. What business was this of Estrada to organize a preparatory commission for constitutional reform? This was the argument of Gonzalez, of course. Okay. So, Justice Narvasa was asked to comment, etc. But before the hearings were held, the Preparatory Commission on Constitutional Reform had already become functus officius. The Commission had already finished its work. Kaya binigyan ng timetable ni Joseph Estrada and nag-submit na ng recommendations. It was no longer existing. So, the Supreme Court simply dismissed the Ramon Gonzalez petition and said, unfortunately, the issue had become moot and academic. In Lacson versus Perez, Pampilo Lacson went to court to challenge the constitutionality of the Presidential Act proclaiming a state of rebellion in Metro Manila. Pampilo Lacson said there is nothing in the Constitution that authorizes the President to declare a state of rebellion. Yun. Unfortunately, again, before even the hearing of the petition, President GMA had already withdrawn her proclamation declaring a state of rebellion. Tapos na. So, academic na. The Supreme Court simply dismissed the petition of Pampilo Lacson. In a little while, titingnan natin, because after Lacson did that, some other people also filed petitions, including San Lakas, Partido ng Manggagawa, etc., etc. In a 2004 decision entitled San Lakas versus Secretary Angelo Reyes. We in just detail. Pero ito, pinakikita ko lang yung nagiging moot and academic. In Atlas Fertilizer versus Secretary of the DNR, the Supreme Court said what was an issue was the constitutionality of including in the Comprehensive Agrarian Reform Law prone farms. Prone farms. These are not farms. Sabi nila, bakit isasama ito? Hindi naman ito yung rice lands and corn lands. Hindi naman ito. Unfortunately, again, when the case was heard, Congress had already passed a law excluding prone farms from the Comprehensive Agrarian Reform Law. Ano pa ang pag-uusapan? Wala na. Wala nang pag-uusapan. Okay. It need not be such that the issue had become academic. It may be that there is no actual controversy to speak of, no actual case to speak of in the first place. As in the case of Fernandez versus Torres. What happened in Fernandez versus Torres? In Fernandez versus Torres, Ruben Torres issued a circular prohibiting temporarily for a certain period the deployment of Filipino female performing artists, deployment abroad, Filipino female performing artists below 23 years of age. Several Filipino performing artists, women, had existing contracts to perform abroad. With the Ruben Torres circular, they were prohibited from leaving the country. And so they went to court. They went to court and challenged the Ruben Torres circular on many counts. Violation of the Equal Protection Clause. Bakit 23? Bakit hindi 21? Bakit hindi 25? Bakit hindi ganyan? Okay. Due process. This was issued without notice, without hearing. It impaired rights. It impaired property rights. Violation of the non-impairment clause. They have existing contracts to perform abroad. Without even a hearing, the Supreme Court dismissed the petition filed by the performing artists. Why? The Supreme Court noted that under the circular issued by Ruben Torres, there was a provision to the effect that even as performing artists, Filipino female performing artists below 23 were prohibited from leaving the country. In extremely meritorious cases, the Secretary of Labor may exempt some performing acts. Sabi ng Supreme Court, nowhere in the petition did the petitioner allege that they applied for exemption and were denied exemption. Nowhere in the petition did they even allege that they did not apply because it would have been useless to apply, inasmuch as all applications for exemption are denied. Absent this allegation, the Supreme Court said, there is still no actual case or controversy. Therefore, there can be no basis for the exercise of the power of judicial review. The case was dismissed. At this stage, class, even as we will discuss this again, let me just call your attention to a principle in administrative law which I am sure you know about. Because if there is anything that you recall in administrative law, it is this principle, the principle of exhaustion of administrative remedies. Ito, tingnan nyo. There was an existing administrative remedy open to the performing artists. They did not avail of the existing remedy. They went directly to court. And so, even on that basis, their petition could have been dismissed also. But I just want you to recall exhaustion of administrative remedies. When a petition in court is dismissed because the petitioner has failed to exhaust all existing administrative remedies, what is the technical ground used by the court when it dismisses the action? The case is dismissed on the ground of lack of cause of action. Lack of cause of action. No actual case or controversy, ang sabi ng Supreme Court dito in dismissing it. The case was prematurely filed. Ganyan. Alright. Now, class, even if the case or the issues in the case have become moot and academic, even if the issues in the case have become moot and academic, the court may still take cognizance of the case. One, when the issue raised is capable of repetition, yet evasive of review. And second, when the court feels called upon to exercise its symbolic function. My readings show that in 1997, when the Supreme Court decided the case of Alunan versus Mirasol, the Supreme Court made mention of this as an exception precisely to the rule that when the issues shall have become moot and academic, the case will not be entertained at all. In an American case, in the case of Roe versus Wade, a pregnant woman went to court to challenge the constitutionality of abortion statutes passed by the state legislature of the state of Texas. The abortion laws, in effect, provided that it was unlawful for a pregnant woman to voluntarily expel the fetus or to do anything harmful to the fetus. The pregnant woman, who obviously in America was or belonged to the pro-choice as against the pro-life groups. Sa Amerika masyadong matindi yan noon. Brought suit. Pregnant siya noon. For the state, for the court to be able to decide the case, it will take over a year. By the time the case is probably heard, nanganak na yung babae. Hindi na pregnant. Hindi na siya ngayon proper party. Kasi hindi na siya, the issue had become moot and academic. Pero sabi ng Supreme Court sa US, we can take cognizance of the case. We entertain the case. Because although it has been, the issue has become more academic, yet it is possible to arise again. Magiging pregnant pa uliyan, magpapahin na naman yan, ibibisibis na naman, dahil makakasak na naman. So, all right. Dito sa Alunan versus Mirasol, the issues were the authority, the basic issue was whether or not then Secretary of the DILG, Rafi Alunan III, ba yun? Alunan III, acted within legal authority when he said that there need not be an election of the Sangguniang Kabataan in the city of Manila. Election ng Sangguniang Kabataan 1992. But the Manila Sangguniang Kabataan had elected had elected in 1990 prior to the effectivity of the local government code. Sabi ni Alunan, kay eleksyon lang, ilampas isang taon pa lang ng eleksyon dito sa Maynila. So, wala nang eleksyon. Yung mga nanalo noong 1990 should go on and continue as Sangguniang Kabataan officials. While in the rest of the country, they elected in 1992. Okay. The other members of the Sangguniang Kabataan went to court. Nanalo sila sa trial court against Alunan. Alunan went out. It took the Supreme Court until 1997. The Alunan ruling was handed down in 1997. So ano nangyari? In 1996, nag-eleksyon na uli. Eleksyon na naman, nationwide, including the city of Manila. So ano pang pag-uusapan? Ito na, nag-eleksyon na naman uli. Ano pang tapos na? The Supreme Court said, the case can be entertained because it is capable of repetition, yet evasive of review. Kasi, pag ina-updatean na naman, in Roe versus Wade, the Supreme Court said, the two assumptions are, first, that the controversy, the issue will be terminated before it is fully litigated dahil naging moot and academic na. And the second is the petitioner who questions there is a probable expectation that the petitioner or whoever questions the constitutionality of the law or the executive act there is reasonable expectation that the problem will arise again with respect to the petition. So, given those two conditions, which brings us to that case of San Lakas versus Secretary Angel Reyes, because this is included in your coverage. The San Lakas ruling was promulgated in February of 2004. San Lakas, as a political party, registered under the party list system. Partido ng Manggagawa, as another political party. Several NGOs, and a number of 2 congressmen and 1 senator, all filed cases directly with the Supreme Court, challenging that state of rebellion proclamation of Gloria Macapagal Arroyo. As already intimated earlier in the case of Lacson versus Perez, GMA withdrew the declaration. So naging academic na. Yet, San Lakas and the other petitioners claim this has to be ruled upon. The issues we have raised must be ruled upon by the court, because it is possible that the President may issue another proclamation. Matagal pang Presidente ito. Pwede mag-issue ng proclamation again, state of religion. And the courts must clarify, will a declaration of state of rebellion suspend the privilege of the habeas corpus? Can people be arrested without any warrant of arrest? Will they be entitled to bail if arrested? And so on. These questions have to be resolved, sabi ng petitioners. Kaya, capable of repetition. Pero ano na lang, pag pino-question mo ang kanyang proclamation, sasabihin niya, sige, tirahin muna natin, pero malapit na mag-hearing, withdraw. Dismiss ang petition. Maya-maya, pag medyo tahimik na ulit, tira tayo ulit, umagat na naman, okay. Ayan, file na naman sila Supreme Court. Tapos, withdraw na naman, okay, dismiss na naman lahat ng petition. So, fearing precisely the possibility that this issue may be repeated, or that the petitioners may precisely be subjected to the same problem. So yun. Okay. The second case is symbolic function. The symbolic function is best illustrated in the case of Salonga versus Panyo. In Salonga versus Panyo, we have a former, an American citizen of Filipino descent, who during the Marcos years came to Manila from the U.S. and stayed at the old YMCA dormitory at the back of City Hall. Yung old dormitory ng YMCA, hindi yung bago na. Inside his room, he tinkered with a homemade bomb. The homemade bomb exploded in his face. Fortunately for him, he survived. But he lost one eye. He lost hearing on both ears. He lost one arm. And on top of that, he was arrested. Okay. All his personal belongings were taken by the authorities and ransacked. Among the personal belongings of this fellow, Victor Lovely, was a picture, a photograph, taken many years before, taken in America, where Victor Lovely was standing beside Jovito Salonga at naka-akbay si Jovito Salonga sa kanya. Obviously, on the strength of this photograph and perhaps certain admissions made by Victor Lovely after torture, 2 criminal cases for subversion were filed against Jovito Salonga, filed with the RTC of Quezon City. Salonga went directly to the Supreme Court, asking the Supreme Court to order the 2 RTCs to dismiss the cases against him on constitutional grounds. Clearly, no due process, etc. Okay. It was Salonga himself who argued this case in the Supreme Court. But class, as you know very well, under the Constitution, even under that Constitution that we had in the 70s, the court is supposed to vote first before assigning the case to a justice who will then write the ponencia. The other justices who do not agree will write their dissenting opinion. So, dun sa voting na yon, in an advanced session of the Supreme Court, majority of the members of the court voted to grant the Salonga petition. That same afternoon, Marcos was informed that this will happen. You can just imagine, nung panahon na yon, Marcos did not want to lose cases before the Supreme Court, especially on constitutional issues, because it would be an embarrassment on the Marcos government. So, that same evening, Marcos called his pride boys, the pride boys of the administration at that time. Of course, you have Espelito Mendoza, the Secretary of Justice at that time, I think Macaraig, or even I think Catalino Macaraig was only the Secretary at that time. He had other Dolong Lazaro, etc. They had a meeting in Malacanang that same evening. And they discussed the problem. Nakakahiya na naman pag lumabas yan, Supreme Court decision. Bugbog na naman ang gobyerno, etc. Si Salonga pa naman. Okay. So what did they agree on? They agreed that inasmuch as the decision will not be forthcoming within the next 2 weeks or so, kasi gagawin pa, at iikot pa for the signature. Agad-agad. Secretary of Justice, why don't you order the City Fiscal of Quezon City to file motions to dismiss the 2 cases? Have them dismissed. Dismissed before the Supreme Court can promulgate its decision. Because then, if the cases are dismissed in the RTC, there is nothing more that for the court to grant. What was Salonga asking for? Dismissal. The cases. Kung dismiss na, wala na. And so, the Secretary of Justice, the following day, directed the City Fiscal of Quezon City, somebody named Sergio Apostol, to file motions to dismiss. Ginawa naman din kaagad ni Fiscal Apostol. Within 3 days, they had certified court orders dismissing the cases. Immediately, the Solicitor General went back to the Supreme Court on a manifestation and motion. Manifestation to the effect that the cases against Salonga, subject of the petition, had already been dismissed. And that therefore, inasmuch as the issue raised by Salonga become moot and academic, the case filed by Salonga should be dismissed. Unfortunately for them, the Supreme Court decided not to dismiss the Salonga petition, invoking the court's symbolic function. The function or the duty of the court to provide guidelines, to formulate guidelines, fundamental principles, and the symbolic function to educate the bench and the bar on the extent of the enforcement and protection afforded by constitutional rights. And so, yun. May mga cases na naiba after that. Yung kay Evelio Javier, it was a petition filed with the COMELEC muna to declare the election of Pacificador as Batasang Pambansa member invalid and to proclaim him as the duly elected member Batasang Pambansa. This was decided by the Supreme Court after the EDSA Revolution. After the EDSA Revolution, Cory Aquino had abolished the Batasang Pambansa. Evelio Javier was already dead. Ano pa ito? Ano pa? I-proclaim mo na duly elected. Wala na. Wala na rin yung posisyon dahil abolished na rin Batasang. And yet the Supreme Court did not dismiss the Javier petition. The Supreme Court decided the case just to say, if you look at the case, the decision, it is I think it's something like 12 pages written by Justice Isagani Cruz. About 3 pages are the issues and the legal reasons of the case for the decision. 9 pages are actually an eulogy on Evelio Javier. Which, nung panahon na yun, talagang medyo ano yun eh. So, yeah. Okay. Let us just take a brief cigarette break. Like 2 sticks of cigarette. Not smoke together. Yeah.